Good afternoon, everyone, and welcome. It's great to have you all here. Welcome to the University of Richmond School of Law. To our alums, we are always delighted to have you come back for yet another fascinating program here at the law school. This does promise to be just a great program, and we are thrilled to have the speakers that we have. We have with us today Laura Lee Miller of the firm of Harmon, Clater, Corrigan, Wellman. Get all the names right there. And our own alum, Rick Clow at Google Ventures Partners. Rick, as many of you know, was the founder of Jolt, and in case you have not been told, it was the first ever completely online journal, beating Harvard by several weeks. I'm particularly excited to have this program. Jolt was part of an early effort where we were really at the cutting edge, the first school in the country to require laptops, and then Jolt. And we've continued to add components of technology and innovation, iPads for the students in the clinics. We've had courses on technology and legal practice. And we've had an ongoing, what we call technology boot camp for our 3L students on the theory that before anyone graduates from law school, there's some things you ought to know about technology. We can't cover all of it in 2 hours, but there are some teasers out there to just make sure our students are really prepared for the world that's out there. So with no further ado, let me turn things over to Nicole Alban, our editor-in-chief of Jolt. Take things over.
Hi everyone, thank you for coming. As Dean Perdue said, I am the current editor-in-chief of Jolt, and so it is my great pleasure to introduce our founding editor-in-chief, Rick Clow, who is a 1996 graduate of the University of Richmond Law. He leads the partnerships team at Google Ventures, where he connects the largest companies in the world to Google Ventures' portfolio. Mr. Clow was previously a product manager at Google, where he led product initiatives on Blogger, Google+, and YouTube. His earlier professional experience includes leadership roles at several software and internet startups. He was an early employee at FeedBurner, where he ran the publisher services team until Google acquired the company in 2007. Mr. Clow received dual degrees from Lafayette College, and as Dean Perdue also mentioned, started the Journal of Law and Technology while he was a student here at Richmond. Outside of his love of technology, Mr. Clow is also a political junkie. He provided technology advice to 3 U.S. presidential campaigns, ran the campaign blog for President Barack Obama in his 2004 Senate race, and ran product strategy for Google's presence at the Democratic National Convention in 2008. He is a member of the Board of Directors of the National Center for Women and Information Technology and Defive Ventures Bay Area. Please join me in welcoming Rick Clow.
Thank you, Nicole. Thank you, Purdue. It is a thrill to be back here, not just on campus. We don't get back very often. It's not the easiest trip to make in San Francisco, but to be back in a new courtroom, which, as I was telling a couple of the faculty just recently, in many ways my entrepreneurial career started in this new courtroom. We had a symposium in the spring of '95 about cyber community. We weren't very good at naming our things back then, so apologies. But it was an invitation to some folks, some professors from other law schools, a couple of practitioners, to talk about emerging trends in technology and the law. And what started at that symposium then led to a couple of articles that were the first articles published in that inaugural issue of Jolt in the spring of '95, tax day, if I recall. And here, let me dismiss that message. And so I was thinking about this and talking with Roger. It's important for you all to know I do not practice law. I am here as a venture capitalist, a nerd, I want to make sure that you understand that I figured I'd put my law hat on and give you a disclaimer just to make sure that you understood that this is not legal advice. I'm here more to talk about the tech side of the equation. You're going to hear from Laura in a little bit about some of the more legal issues regarding some of the technology that we have. So I'll emphasize the AI part of my conversation and talk a little bit about what I think this might mean for law practice, and make sure to leave some time for questions. Roger had made a point of making sure that I'm here really as a kickoff to this conversation, and I would love to know if there's any part of my background that would be interesting to talk about. We'll leave time towards the end for questions. So I thought back to that spring of '95, right, when we were here in the moot courtroom having that symposium, when Roger asked if I would give a talk here in the moot courtroom. And so I went looking online, yes, on Google, and found this article from last year in the Atlantic that asked the question, why are law firms trapped in 1995? And I thought, well, that's kind of interesting. That was the last time I actually worked inside of a law firm. That summer of '95, I was a summer associate at a law firm here in Richmond. And look, the headline was a little alarmist and a little bit more provocative. The basis of the article itself was pretty thoughtful, asking some questions present day about where the technology is taking us and what it means for the practice of law, and highlighted one of the issues that not only are there law firms that have not made the complete transition to digital technology, maintaining a lot of paper files, but also the business model itself. So I thought back to some more to '95. Yes, we were the first law school to require students to own laptop computers. They did. We were excited when Windows 95 came out, not because Jay Leno was launching Windows 95. I still don't understand what The Tonight Show had to do with Windows 95. But our laptops were, and that actually was my laptop, beautiful device, really underpowered and heavy. When I showed up to the law firm here in Richmond, I walked in on day one with this laptop. I'll actually tell you a funny story. This actually is a picture of my laptop. And I was the only person in that law firm, other than a secretary, to have a computer in my office. The partners in that law firm had one of these. Now, those of you who are my age or older, don't answer the question. Those of you who probably weren't even born yet, which really annoys the hell out of me, that's how old I am now. Anybody know what that is? Think Siri, but with a tape recorder. It was a dictaphone. Very good. What the partners were doing in this law firm, they would dictate, their secretaries would transcribe, and then the partners would review the transcription of their dictation, and then the secretaries would incorporate those edits into the resulting document. Now, I share all of this with you not to talk about how old I am. That really is hard for me to wrestle with, but to talk about what happened that summer that told me that perhaps my future was going to be in tech rather than law. What happened was the partner that I was working for gave me an assignment. She asked me to do some research on a particular topic, write up a brief. She was pretty sure it was going to take about 3 days. She knew how much case law there was to do in the research. And this was Monday morning. She'd see me Wednesday afternoon. Great. So I go to my office. I go to work. And you cannot imagine how proud I was to be walking into her office at Tuesday at lunch with a finished product. I mean, I was a good hire. I'd done it in half the time. And she was pissed because she couldn't bill 3 days of my time. And she didn't know what to tell me because she wasn't hoping to talk to me until Thursday with the next assignment. So I thought about that for a little bit, and I thought, well, how weird that this device, which, believe it or not, given that we have way better computers these days, I loved this machine. Loved what it allowed me to do. Could be a risk to this profession that I was studying to enter. So, The funny story about that picture of the laptop, I don't walk around with digital copies of the laptops I have owned over the last 25 years. It was actually the picture of my laptop that was taken in one of our study carols upstairs in the issue in the winter of '95 that was Richmond Law Magazine's focus on its embrace of technology. And there's a bunch of stories in there written by Richmond Law alums, and then a piece from me about what we were doing with that symposium and with the inaugural issue of Jolt. But I thought it was interesting that what Dean Harbaugh talked about at the time in his sort of introduction was about this unease at watching where the profession was heading as the first law school to have students coming in where every single student owned that unbelievably heavy laptop. We'll come back to that in a little bit. I've talked about, you heard in my intro, I've been on the Google campus now for 11 years. For 4.5, almost 5 of those years, I was a product manager, which really means that I just get to be the person responsible for making sure that the products that we ship to our users are accomplishing what they are intended to accomplish, that they're responsive to when users say it doesn't do what I want it to do, when there's features we want to build, that we change them. And then 7 years ago, I moved over to GV, where we are a venture capital firm. We invest in tech startups. A couple of years ago, something really profound happened. And any of you who are either not native English speakers or who work across multiple languages may have noticed in the summer of 2016 that something pretty remarkable happened. Google Translate got a lot better, like a lot better. And if you, like my kids would have a lot of fun. They would take a block of text and they would translate it into another language, and then they'd translate it back into English and talk about how funny it was that the resulting text sort of made sense, but was obviously made by a computer. Well, part of the reason for that was that historically Google Translate was a very sophisticated computer program. Lots of if-then statements. If you see this block of text, replace it with that block of text when somebody wants from English into Spanish, or from French into Greek, or from Greek into Russian. And that's how most computer programs historically have been written. Lots of lines of code designed to accomplish a very precise outcome. But in 2016, they replaced it. And they replaced it with a completely different foundation, which was what's called a neural network. Now, it's just a fancy term for instead of teaching a computer or telling a computer what to do, you're teaching the computer how to learn. So it looks at big training data sets and looks for positive outcomes and says, okay, I want to do more of those good outcomes. And it looks for examples of bad outcomes and says, all right, I want to avoid those. Now, the reason that they did this was the engineers working on Google Translate at the time had a suspicion that the computer would get better at identifying translations than the people were able to write hard-coded if-then statements. Now, it was a guess. There was no way to know ahead of time. So they launch. In the 8 years prior that Google Translate had been around, they had been monitoring their translation quality. If you've ever used Google Translate, periodically you'll get asked, how was this translation quality? And if you actually speak both languages, you could tell it. Like, well, it actually was pretty terrible. Or, yeah, you nailed it. Over those 8 years, they achieved one step function increase in quality, which is good. It generally was getting better. And they added more languages, and the translation quality kept going up over time. In the week after they replaced the program with a neural net, they achieved the same improved quality. And then it kept getting better. But that's not the profound part. The profound part was the system that had been taught to learn effectively invented its own language. A language never spoken by a human, never read by a human, and never actually represented in words that we would understand as words, for the sole purpose of translating any one human language into any other human language. When I read that, I saw that in the New York Times article that was written about this. It came out towards the end of 2016. And I thought, well, that can't be right. So I actually talked to a friend of mine on the Translate team, and he goes, well, I kind of think it is, but let me connect you to the engineers on the team. And sure enough, that is exactly what happened. It's called an interlingua. As a result of that, Google Translate continued to get better. And it got easier for them to add languages that they hadn't added before. So they could add Klingon, for instance, which I thought was pretty fun. So if you ever want to translate into Klingon and impress your Trekkie nerd friends, you now have the tools to do so. That notion of the systems getting smarter, faster, is what's at the core of when we talk about artificial intelligence. Historically, when we talked about artificial intelligence, it was about computers pretending to be as smart as people. But increasingly, at least when I talk about it, when my colleagues talk about artificial intelligence, we're talking about when the systems themselves have learned to do things potentially even better than the humans can do themselves. I've got a video. Let me make sure the audio is on. I'm just going to play you about a minute and a half of this video, and I think you'll see why in just a sec. Let's hope the tech works.
For decades, human beings have played games against computers. At first, computers struggled, but then they started winning.
What's it? What is free? Yes.
And now they've become so dominant that they're raising doubts about the future of humanity. The latest emblem to existential threat is Google's DeepMind project, which created AlphaGo, an AI program that's become unbeatable at the most complex strategy game on the planet. While the game of chess has 10 to the power of 20 possible outcomes, and a game of chess has 10 to the power of 40 possible outcomes, Go has more than 10 to the power of 80 possible outcomes. AlphaGo is trained to analyze situations itself by breaking the game down into tiny parts and visualizing all possible moves. Last week, it played the world's best poker, 19-year-old Kojima, with the help of a human hand. AlphaGo beat him 3 times, and after doing what it was designed to do, retired from the game.
在这次比赛完之后，在他继续又不停的进步之后，我觉得他对我而言就是100%。
If a system like AlphaGo can learn all the moves in Go well enough to beat a person, then it has the potential to replace lawyers and accountants among dozens of other jobs. It might be perfect, but it has no way to navigate human politics. The Chinese government banned it.
So, I'm not sharing that to tell you that AlphaGo is replacing lawyers in a week. Your degrees still have value. There will continue to be a role for lawyers going forward. I'm going to come back to that comment, though. Let's skip. See, the tech worked almost too well. It's really fun. If you look for pictures of humans playing against AlphaGo, it's basically a bunch of pictures of people holding their heads in their hands, completely flummoxed by this computer. So I want to reinforce something that was said in that video. I actually went and talked to 3 different people to make sure that I was understanding the following statistic properly. There are more possible moves in a game of Go than there are atoms in the observable universe. So when we have thought historically about computers playing games, right? People think about Deep Blue, right? When IBM beat Garry Kasparov 20 years ago. It was for that reason when you saw the representation of how many possible moves there are as many possible moves in chess times as many possible moves in chess. That is an extraordinary explosion of possibility. We do not have enough compute power in the world today to do a brute force playing of the game of Go. So in 2015, when people surveyed the state of the art in artificial intelligence experts and people who were 9 Dan, which is the ranking in Go, that is the highest level you can be ranked, the consensus, the belief, was that we were 10 years away from computers being good enough to beat a ranked player of Go. And then 6 months later, Lee Sedol, pictured here, who's a top 10 player in the world, was beaten by AlphaGo. So something that the experts were convinced was 10 years away happened 6 months later. Or said differently, we are 10 years ahead in where artificial intelligence is taking us from where everyone in artificial intelligence thought we were. Which means the next 10 years get pretty exciting because the acceleration of this is happening quickly. There's one particular move, and by the way, I don't understand the game of Go. I did watch the live stream because it was pretty obvious that something momentous was happening back in 2016 when Lee Sedol was playing these games. And it was fun watching the color commentators. I mean, not quite Al Michaels, Chris Collinsworth caliber of play-by-play. But there was one move in particular. It was move 37 in game 2 of this match. And if you're really interested, if you do play Go, you can watch the match. But if you don't, like me, it won't do you any good to watch it because it's just a bunch of tiles showing up on a map. But when the black tile went down, the two commentators looked at each other and were like, well, that's a mistake. It's clearly a mistake. And then they have the translation of some of the Chinese and Korean commentators who are saying, finally, we're going to see Lee Sedol pull it out because the computer has clearly stumbled. It actually wasn't a mistake. Fan Hui was a ranked Go player who had also lost to AlphaGo and commented that it was not human, but it was beautiful. There were a lot of articles written about this particular move, and the one that really stuck with me after I read this article and this notion of it being beautiful was that it reflected an understanding of the game that no human had. This game that humans have been playing for thousands of years, considered to be the most complex strategy game humankind has ever created, the computer understood in a way that we did not. And not me, because I don't understand any of it. The professionals, the ranked players, even the commentators, no one understood why move 37 could possibly work, because it did not sync with their understanding of the game. But when they went back and rewound the match and watched it, that was clearly the move that won the match. They just couldn't understand why. Which, to me, this goes back to the Google Translate example, where the system has created its own language for understanding language that we do not and cannot. Another picture of Lee Sedol holding his head. And this comes back to the quote in that Vice News summary predicting the replacement of lawyers. Again, we're not being replaced. You're not being replaced. But it was this idea that Go is as complex as anything man has ever created. And Go figured it out in a way that humans have not. There are a lot of things less complicated than Go that presumably systems like AlphaGo will be able to similarly deconstruct and extract meaning and see patterns and identify actionable insights that humans simply cannot. Which then invites us to think about what this means for Martindale books on a... No, it's not about Martindale. It's thinking about what this means for the practice of law. Go back to my example about taking a day and a half instead of 3 days to do an assignment. When you're paid by how long it takes to do something, well, you don't have any incentive to do it quicker. In fact, exactly the opposite. But when the systems are able to, in a heartbeat, identify the thing that is worth knowing from a pool of data, well, wouldn't we want to use that in service of then providing counsel and advice and insight? I think so. But then it gets harder to think about what the business model looks like, right? I thought it was fascinating in this, again, Googling for what are people in the profession talking about, because I don't work in the profession, so I don't have my finger on the pulse of what this means to be a lawyer today. But I thought that this guy at American Lawyer Media had a really fascinating insight. I added the boldface because 2 of the obstacles to implementing AI, actually all 3, but 2 in particular, have nothing to do with the tech. He's just assuming the tech into existence, which I think is the right assumption to make. It's coming. In some ways, it's already here in some vertical applications. But what's the comp plan for the professionals, and what's the fee arrangement to the clients? If those are the barriers, those are barriers for the law firm, but not for the practice of law, right, if you distinguish those 2. So, from a format perspective, leave for questions after we've both presented. Do you want me to take questions now? How do you want me to do that? You want me to do questions now? Okay. So as you think about questions to ask, I've covered a lot of ground that presumably is not covered day to day, either in class or in your practices. So what I did was I collected a bunch of the articles that I reread or found in preparation for giving a talk, found a couple of links to videos that I thought would be interesting. So if any of this was compelling, scary, exciting, it's all in this doc, so that's uofrlaw-ai@arcloud.com. So I figured that might be a useful way to put it all in one place. What questions can I answer? About Google, about venture capital, about the startups we invest in. I always like talking about them. Talk about my kids. Carl's got the mic. Get the mic. It's over here.
There's been some recent studies that have come out showing that Virginia is one of the most corruption-prone states. And yesterday, the Virginia Mercury published an article that said that Virginia was second only to one in terms of making it difficult to vote. I was wondering if you had any thoughts on this in reference to AI and Google in the future.
I have a lot of thoughts. I don't know that I have any thoughts as pertain to Google specifically. I don't know, I mean, other than, and I should clarify, GV operates as a completely separate entity within the Alphabet family of companies. So I used to work at Google. I actually now work at GV. So again, I'm putting my lawyer hat on. It's a little dusty, but make that distinction. Google has a lot of terms. This started actually in the 2008 election, where if people were searching for things that looked like they were voting-related terms, we wanted to make sure to get people to their polling place so that we could surface that, make sure people knew when the voting registration deadlines were. We actually do that all over the world, depending on what the mechanics are for how people can be eligible to vote. Some countries, it's automatic. Imagine that. As a citizen, I think it's unconscionable when we make it harder for citizens to vote. I think I was talking just ahead of this talk. I spent 4 days last week with 3 members of Congress, and there were a dozen of us venture capitalists on a bus tour through the South. So we went from Charlotte to Columbia, South Carolina, Orangeburg, South Carolina, and ended up in Atlanta. We visited 7 or 8 historically black colleges and universities. Georgia is getting quite a bit of press right now for trying to cull the voter rolls. I met a woman Thursday night in Atlanta who had been pulled from the voter rolls because her middle name on the voter registration did not match the middle name on her driver's license. It was an initial versus a full name. And that was used as evidence to pull her from the voter rolls. Fortunately, she found out. She was able to go in. Took 3 trips to, forget which agency it was, to straighten it out, but finally got it straightened out. But when we make it hard for citizens to vote, I think we are doing a disservice to the country. I think I had this conversation with one of the congressmen that was with us, that it seems like there's a role for technology there. I think the technology makes it easy to query against systems. I could do a diff on 2 different data sets and tell you who was on the roll in the 2012 election, who wasn't on the rolls in 2016. Unfortunately, access to those voter files is not something that as my understanding, this is a little rusty since it's been a couple of cycles since I've been closely involved, but is not easy to do, and there are laws around how you use the data that you query. So I don't think, for instance, I could start a startup tomorrow with the express purpose of finding all the people that have been deleted from the rolls and reaching out to them to make it easy for them to re-register, for instance. It's easier if I'm a candidate, and anybody who knows election law can tell me if I'm wrong, because it's very possible I could be. But this feels like incentives have been a little misaligned between those in power in some places and those who have a right to vote but are often frustrated in their exercise of that right. I don't know if that really answered your question, but thank you for the question. Yeah. Back here.
Thank you. With respect to the practice of law, what do you see as the short-term, mid-term, 2-year, 5-year, 10-year impact of AI on the actual practice of law?
I think in a 2-year time horizon, I don't know that there's a huge difference, right? That's a pretty near-term horizon. I know that there are some companies that have started getting some venture funding. So historically, tech and the legal profession, that's where I started my career, they were fairly contained businesses. If you were successful, you might grow to about $50 million a year in revenue, and then you'd get bought by Lexus or West. That was your best case outcome. So there hasn't been a lot of innovation, and there's certainly not a lot of venture money going into producing $50 million outcomes. That's not the business of venture capital. You want to know that there's $1 billion opportunity when you're investing in a company. So I think it's interesting to see that there are several companies emerging just in the last 12, 18 months that are exactly in that space, right? And they're doing things where AI, and you'll also see people refer to machine learning, which is essentially I'm going to oversimplify if there are computer scientists in the room. I'll apologize in advance. But machine learning is really just the necessary precondition to what we would consider artificial intelligence. I consider them two separate things. They often get lumped together, and people will just say AI, ML, and just like one word. But machine learning is really pointing those systems at large sets of data to then interpret and produce some insights. Artificial intelligence is when they're learning from that and then developing their own tools and capabilities, like the AI Google Translate example. I think what you're probably likely to see is pretty big shifts in that 2 to 5 year time horizon, where this stuff moves to the cloud, right? Where it's much easier to harness very broad computing power without having to install it locally on your own machines. And it just requires you to expose whatever your corpus of data is to those systems. It's amazing, I think back on my early days, 97, 98, 99, we were excited when lawyers had email. And it was always installed locally, and they were running their own mail servers, and they always swore that that was the safest thing possible. Now I think there's a familiarity and comfort level with the cloud that makes some of this far more likely to be adopted and implemented. So I think in that 2 to 5 year, you'll start to see a lot of these vertical examples where maybe it's just extrapolating boilerplate terms for contract creation. Some of that already exists where it's very rigid document assembly, but if you could point an AI or ML tool against a much broader set of contracts, I think you would be able to create model contracts from that, or agreements, and maybe even then point it at case law and say, well, maybe there's some opportunity here to navigate within the requirements that we haven't seen before. So I think that's quite likely. And then beyond that, I wouldn't trust my predictions given how little I know of the day-to-day with law practice today. Yeah, Bill.
Hey, Rick, good to see you. The question I have is, how do you think blockchain technology is going to alter the face of what we see on Google? Is there going to be a life after Google?
So, it's a great question. I don't know that so let me back up. So for those of you in the room who may have heard the term blockchain, let me do my best at making sure that we have a common understanding of what that means. You will often see the term blockchain used interchangeably with cryptocurrencies, so the most popular of which is Bitcoin. They are related but separate. So blockchain is really just a distributed ledger. Right? So think about when I go down to the courthouse and I record the sale of my property, that is in a ledger, but that ledger is maintained by the county. There's one. And then, hopefully it's digitized and there's a backup plan in place, but it is one. And I need to trust that the county is going to do its job and maintain that register and be a good custodian of that register over time. There needs to be trust in there, and there needs to be authority from, in this case, the county that's registering it. What a blockchain enables, and I'm using this in the generic term, is that I don't have to have trust with the people I'm doing business with, because as the transaction gets written to the ledger itself is distributed. And the ledger exists on hundreds, thousands, millions of computers, so any one of them can go down, and it's replicated in lots of other places. So it becomes resilient and therefore reliable in a trustless environment. So that's blockchain. It becomes a way of recording that sale, that purchase, whatever that transaction might be, in a distributed way that makes it really easy for me to know that I will always have evidence of that transaction having happened. Cryptocurrencies use that as a way of conveying ownership of the digital asset, which is the coins. And it's unfortunate they're called coins because they're not actual physical coins, it's just some lines of code. So, all of that to answer your question. I think it's early to know what impact blockchain will have. I think it is likely that we will see it in lots of unexpected places. My brother runs a water testing company based in Colorado, and he was telling me one of the things that they were thinking about was using the blockchain as a distributed ledger for understanding water testing measurements that are done in municipalities around the world. One way of, if they do that, that then means that they can give others access to that testing data and start to then point AI and ML tools to ingest that data and do their own analysis and find interesting things. It never occurred to me that that would be a possible use for this thing that is often paired to cryptocurrencies as its most common application. With regards to Google, boy, I don't know. I mean, are you asking in the context of search or in the context of ads? Or
I'm asking in the context of decentralization of control of information.
Yeah.
That the next revolution that will unseat Google potentially is the cryptocosm, which means that information will be widely available to everybody on their own server. So I don't know what the possible implication is, but it seems like there's going to be some evolution beyond where we are today.
Yeah. I mean, the big irony for me is that, you know, I used to run Blogger, which at the time was the largest blogging platform in the world, and I loved this idea that we were giving every man, woman, and child in the world a platform on which to speak and reach the world. Those platforms are owned by a couple of companies. In fact, arguably, the weaponization of those same media is only possible because they are centralized. So I don't know. It'd be super interesting if that distribution of the ledger and sort of the resilience makes it less weaponizable. That would be a really good way to feel optimistic about the future. But I don't know. I'm going to be thinking about that tonight. Other questions? Yeah, right here. Nope, there you go.
Thank you very much. My name's Nadeem. I'm a 1L. Just wanted to say thank you for coming, first of all. The other day I was reading an article online about an application that an individual had created to, I think individually it was, or originally, excuse me, it was for the multitude of parking tickets he had.
Yeah.
He wanted to write a service that would, or an application that would draft appeals for him.
Yep.
And to my understanding, it's evolved into a system which can draft arguments for individuals.
Mm-hmm.
So obviously this has awesome implications for law firms because lawyers possess the ability to, and the technical skills to tailor and filter, edit as they see fit. What I'm wondering is for pro se patrons, what can you tell us about the future advances of AI and machine learning in terms of learning how to edit, to filter, to make these potential draft arguments actually pertinent to whatever specific cause is intended?
Yeah, I mean, so the specific example I think you're referring to, I forget the name of the app, but it was somebody who was trying to figure out a way to automate the appeals of parking tickets, and then made the tool available and had appealed something like 200,000 parking tickets for individuals, and then started going and adding additional cities. Because it turns out that this is a pretty procedurally simple transaction to map out, right? So think about my example of Google Translate and give me a bunch of if-then statements. Well, there's not a lot, right? If parking ticket was issued after parking hours had expired, file the appeal. If parking ticket was not validated by whatever, and it says right here in the code that there needs to be this, it needs to be signed, file the appeal, right? So those are the sorts of things that I think we'll see lots of examples of that, where people writing software are really good at mapping process to outcomes, right? It's one of the things programs, in the way we have traditionally written programs, are really good. What I think is going to be more interesting is this ability to infer and understand what is written to then present an argument. So we were investors in a company called Lattice that came out of some research that was being done at Stanford. And what they had built was a system that learned how to read. Now, first time I heard that, I said, oh, yeah, optical character recognition, got it. And they're like, no. It was not identifying that this is an A, this is a B, this is a C. It was reading the text on a page and understanding it. So the research that they did when they were in school was to read the full body of work in paleontology. And they said, we're going to turn all of these academic papers into a database. And there had been a volunteer effort running of paleontologists who for a decade and a half had been reading the literature and then extrapolating. This is talking about this era. This is talking about this city. This is talking about this region. It's this dinosaur. It's this bone. It's whatever. Once PaleoDB went live, they had a 95% precision with term extraction, whereas the human equivalent that had taken 15 years was in the 80 percentile, 80, 85. They also had more than twice as many terms extracted from the same literature that the humans had been reading historically. They also did a better job of saying Alexandria in some contexts means Egypt, and in other contexts means Virginia. Humans make that mistake more often, because this could say, well, when it's talking about Egypt, it's also referencing these other locations, so I can build a rule that says if this, but in context of those other things, whereas humans tend to make shortcuts, say, I know Alexandria, I got it, and then make a mistake. That, for me, was the first time when I got to, so you heard in my intro, I get to make introductions to large organizations. I was with a government agency this morning, and basically I get to play tech therapist. Tell me what your problems are, and then I will connect you to startups who are solving that problem. And I was talking to an insurance company, and they say, we've got all of these claims adjusters that are writing up notes from accidents. And then they go in a file, and we never look at them again. And she said, well, if I could point the machine at our case files, and it could learn that this particular car always gets in this particular accident, so we should refine our risk model for that. So I think you'll see some of that inform how lawyers start to think about structuring contracts, right? If you can look at your past work product and be smarter about what you've already done. This has been nirvana. By the way, I worked at a document management company way long time ago. And our prediction to lawyers was, you're going to store all your documents in the document management system, and then we're going to tell you what you know. Lawyers in the room, how many of your document management systems tell you what you did 15 years ago and make you smart about it? No hands are up. So I think we'll see more of that over time. Question in the back?
Hi, I am Kate Bauer. I am a 3L here, and I'm actually on the Journal of Law and Technology, so thank you for
Awesome.
that.
Thank you.
And I've worked in predictive coding at law firms before I came to law school, so Jolt actually provided a lot of literature that helped me try to convince attorneys, so thank you for that as well. My question is, you observed that there are some inefficiencies in how law firm compensation is structured sometimes. What market forces do you think will start pushing people away from those inefficiencies? For example, document review in the most expensive cases is about 90% of a litigation budget, but with predictive coding, you can take that down quite drastically, but you see some hesitation to move in that direction, and it seems that it might be clients driving it, but I was curious if you had any other insights into how to push people in that direction.
I think it's already happening, but I think it's still the minority use case, not the majority, in client interactions with their law firms. But I do think it will be clients who will increasingly say, well, you know, I'm seeing tremendous gains in digitizing and applying AI in these sectors of our business. It seems logical that we should be able to do the same here. When law firms embrace value billing as a way of offering to their clients predictability about what a thing will cost, that is highly desirable, but only really possible when you as the lawyer understand what the drivers of what the thing actually costs will be. So it works in both directions. You need to have a high degree of insight into the components of what drives your business, right? So forget about being a lawyer for a minute, and you have a business to run, and there are components, and part of the reason it costs so much is it takes such a long time, and it takes so many people to do. But you're starting to see some law firms experiment. I mean, it's been for a couple of years that they've been experimenting with doing that offshore. So let me do that with highly educated, trained lawyers in India, who we get the benefit of time zone splitting, so they're doing it overnight. And then when I get in the morning, they've got work teed up for me to focus on. But I also think the machines will play a part there as well. It's hard, right? This is true in tech as well, that companies are generally not going to be the agents of their own disruption. They're going to wait for somebody to come along and point out that there's a much more efficient, much more cost-effective, much more impactful way of doing a thing, and then respond. So I think the clients will continue to ask, but I think you'll probably start to see some entrepreneurs who may also be lawyers say, well, we can offer this, you know, we'll charge a fraction of the cost and we'll cap it. Say, this is just document review costs X, always. And that'll be scary for some firms, and there are others who will say, yeah, we'll take that and try and make it work. How are we doing on time? I want to be respectful. Maybe two more questions? Cool.
Hi, I'm James Williams. I'm also a 3L from Jolt. So I just wanted to say thank you again. When you were talking earlier, you said, don't worry, AI isn't here to take your job as an attorney. But I was trying to grasp how AI, aside from looking at contracts and spitting out, so to speak, predictable possibilities, when it comes to the human element, so to speak, like moral values and other things that we create that aren't necessarily considered in the same if-then capacities, is that something that would still be of value moving forward with AI? Because then I would be wondering more about like what could be a possibility for AI within the legal field, because then for more sensitive topics where it's if you do this, then maybe you lose your child, or there are other moral implications. It might be relevant. So I was just wondering, is that something that, adding that human element, is it something that's maybe relevant, or is it just still being...
I think the ethical implications are enormous. And this is one area where the legal profession tends to be out in front, having an explicit ethical component of everything from CLE to its review of the members of the bar. Right? There are a lot of professions, computer science, venture capital included, that don't have that. And you get some bad outcomes as a result, or certainly undesirable behaviors as a result. I think that it's going to be a long time before we are comfortable interacting with machines in the same way that we are comfortable interacting with people. One of the articles that's in the follow-up reading that I linked to talks about the lesson from AlphaGo and Move 37 actually, I'll tell a little bit of the story and then you can read more. They talk about two moves. There's Move 37 in Game 2 and Move 78 in Game 4. Move 32, was the play out of the blue by the computer that no one could have foreseen. It made no sense to the humans. But in reverse, Move 78 that Lisa Dole played in Game 4, they call the Hand of God. That it's amazing. I mean, there's such incredible words that have been written about these games, but that he so stunned the computer, and it's even, I mean, I'm imbuing this machine with human emotion, but to the point that the computer crumbled. And they talk about both being a 1 in 10,000 opportunity, where Lisa Dole was so gifted at the game and his understanding of and his adjustment to the tactics that he pulled a move that the computer had no idea how to respond to, and ended up winning. That was the one game he won. AlphaGo won 4-1. The conclusion of that article talks about that the lesson, at least for the foreseeable future, probably within our lifetimes, is that it is not that it is man or machine, but that it's man and machine. That the reality isn't that the machines are going to replace us all and we're all just going to be sitting watching Netflix, but that we are building and cultivating these systems and then responsible for them. And I think about it, specifically in the legal field, there was a widely publicized case, not a case, but a situation where there was, I want to say it was somewhere in the Midwest, where they were using a predictive analytics tool to predict someone's likelihood of reoffending to determine their suitability for parole. Now, I'm going to get on my soapbox. You saw me, you heard in my bio, I serve on the board of an organization called Defy Ventures. This is where we bring venture capitalists, tech execs to prison. We coach incarcerated individuals on entrepreneurship so that when they get out, they are likely to make an honest living and not go back. Recidivism rate nationally is well over 50%. Within 3 years, people who are released go back to prison. Graduates of our program, that number is under 5%. I share that because one of the other things that is also true of the criminal justice system is that there is a disproportionate incarceration rate for African Americans and people of color versus Caucasians. Now, left to its own devices, the predictive analytics tool then says, well, those white people sure seem to stay out of prison, so we're going to over-index that if it's a white prisoner up for release, we're going to recommend them for release. Well, that's not okay. That is certainly not how that should work. So there is a requirement on us to not just flip a switch, turn the program on, leave the room, and assume it's all going to work out, but make sure that as we build these systems, there are moral and ethical components to them that we are hopefully right now uniquely able to see and anticipate and respond to, so that when we see situations like that, we can ask very hard questions about, okay, A, how did we get here? Like, how is it that this system was allowed to get to this point where we actually put it into production and then said, oh, wait, we might have made a mistake. But then also, as we go forward, this is where folks in my world on the venture and the computer science side are trying to explicitly anticipate these things so that we don't get to that point in the next time. Because I guarantee you there will be other cases in criminal justice for sure where we're going to start seeing more of these models predict let's use them for sentencing. Let's decide how long somebody goes away. Well, I could see similar ways in which that could go sideways pretty quickly. So bias creeps in, right? And there's a lot of thinking going into on the AI side that the only way AlphaGo was able to learn how to play Go was getting access to millions of games of Go. It's the training data. Well, if your training data is biased, your models are going to be biased. So you need to make sure to control for that bias in whatever way it is represented so that the models themselves are not reinforcing that bias. There's actually a term in machine learning called reinforcement bias, where it actually makes the outcomes even more pronounced because it keeps learning from flawed data and then making more extreme models as a result. So I'm glad you asked that. Thank you. All right, I think I want to be respectful of time and make sure we give our next speaker plenty of time. Thank you. I'll be around afterwards. I really appreciate time spent.
Thank you, Rick, for those insights into the future of AI and the law. I'm sure we'll see many of those changes coming down the pike, and new ones that no one has thought of yet. Our next speaker will address the topic of social media, a very timely issue that Jolt is actually going to address in its next symposium, February 22nd, so mark that on all of your calendars. That'll be coming out soon. But Miss Laura Lee Miller is here today, and she, as Dean Perdue said earlier, is an associate at Harmon, Claytor, Corrigan, and Wellman here in Richmond, Virginia, where her practice focuses on general civil litigation and insurance coverage law. Prior to joining Harmon Claytor, Ms. Miller practiced in a DC law firm for several years, representing insurers in coverage issues and disputes arising under various types of general liability and professional liability insurance policies. She is a graduate of the University of Virginia and the University of Virginia School of Law, and her most recent scholarship in the Journal of Civil Litigation explores e-discovery developments in Virginia, and she is a member of the Richmond chapter of Women in E-Discovery. Please join me in welcoming Laura Lee Miller.
Thank you very much. That's a very difficult talk to follow, especially because I'm having a minor existential crisis about the upcoming role of computers in all of our lives, but I will try to pull you out of that and into the happy world of civil litigation. So as was just alluded to, this talk today is going to largely focus on social media, and I'm going to throw a few statistics and information bits at you to begin with, but I do think it's important to note, first off, that this is obviously something that we're all very familiar with in our daily lives, but I think that a lot of the information that I'll share with you, these are statistics and data that you might not actually think about on a daily basis about just how prevalent this information is today and how far we've come over even just the last 5 years, over the last 10 years, in terms of how social media has pervaded every aspect of our lives and how it's pervaded the litigation scheme as well. So, to begin with, I do not know any of you, but I've been able to gather a couple of bits of information from people that I interacted with in terms of preparing for today's event. So, we have a few friendly faces up here, but I can tell you that, for instance, Rick just bought a new Pixel. He is really enthused with the screen call function. He tweeted about, I'm guessing about 19 hours ago now, that he thinks that the screen call function is glorious in all caps. There was a GIF that was included with it too. Roger helped with organizing this event as well. He thinks that Minnesota has the best state fair that the nation has to offer. So anyone from Texas, talk to Roger. And then Maureen Moran, I'm not sure if she's here this evening, but I was also in contact with her about this event today. And I can tell you from public information on the FEC's website that she made a political contribution to a candidate back 2013, 5 years ago. That's all public information, and it took me about 60 seconds to gather it. So if you think about the world of data that exists out there today that lawyers are now starting to use full force in terms of not only preparing how to attack an opponent's case, but in terms of how they build their own defenses in their own case, it's absolutely staggering. Mobile technology certainly changed the whole world that we grew up in, or at least that I grew up in. This data that I'm showing you, I've made it purposefully outdated, and the reason being that I wanted to put a marker in 2014, that's just 4 years ago, so you can imagine how much it's come even since this point. Back in 2014, 90% of American adults had a cell phone. That number has only grown. 58% of American adults had a smartphone in particular, so something with internet connectivity. 32% of American adults had an e-reader. 42% of adults had a tablet computer. 98, this one just absolutely boggles my mind, 98% of 18 to 29-year-olds own a cell phone. That has to have approached further to 100% today. But if you think about even just what percentage of that age bracket lives in poverty in this country, that certainly is more than 2%. It's such an integral part of our daily lives that even those who are living in poverty have to have access to this technology in order to function. 75% of 12 to 17-year-olds owned a mobile phone in 2014. I do not have children myself, but I'm sure that those of you who are parents, you've experienced the challenge of when do you first provide your child with a cell phone? How much technology does that cell phone have? My first cell phone that I ever got, it was when I was in college. My mother didn't have to fight that battle, luckily, but thinking ahead to what I would do with my own children, I'm not sure I have a good answer to that question. All of this data and information, though, leads me to one central question. It's, why does my mother ignore my text messages? No, it's not that, sorry. It's, what else are people doing with their devices on a daily basis? And I can tell you that a large part of what they're doing on their devices is building a daily trail of what becomes evidence in civil litigation. It's building a database that lawyers are starting to mine actively. Social media is growing right along with the mobile device expansion. Facebook now, we're back up to current statistics. 2018, 2.23 billion users. The current world population is 7.2 billion, I believe. 562 million people on LinkedIn, 335 million people tweeting, though maybe some bots there. I'm not going to comment on that issue. 1 billion users on Instagram, and it goes on and on. I mean, there are new apps that are coming out every day. I've included up to Snapchat. That's about as current as my app knowledge goes. The people who are really in the know in this industry, I'm sure, know what the next up-and-coming thing is. I don't know what it is, but I guess we'll all find out together. But from our perspective in the legal world, there's rarely a situation where we would say, gosh, I really wish I had less information about my own client, or I wish I had less information about the plaintiff in this case, if I'm on the defense side. My husband practices criminal defense law. He begrudgingly agreed with this statement and thought that he could think of at least a couple of scenarios where maybe he didn't want to know all of the information. But I digress. At least on the civil side, more is usually more. And as attorneys, that should both excite and terrify us, right? That we have access to what our clients have built in terms of their online presence over the course of years, typically. And this isn't just individual clients, mind you. Corporate clients are also starting to do this. We represent hospitals in my firm, nursing homes in my firm that have YouTube channels. They have Twitter accounts. They have Facebook pages. They're on the social media presence too. So if you're thinking about it from a practical standpoint in discovery and litigation of, well, I don't have, this is corporation versus corporation. There's no real need to dig into social media on this. You might be missing something, and I think that it would be wise to at least consider that at the outset of the case. So the problem that people have with, Googling yourself and all of that, the data's out there, and you can try and run from it, but you can't hide. I hide behind a very common last name now, but my maiden name is a long German name, Sennewald. And if you know that name, you can find a few different pieces of my past. You can find my engagement photo to my husband. Up there. He's very sweet. But you can also find, and it's a little small, I apologize, but you can also find a non-secure Google Doc that was prepared by my wedding photographer that has all of the information that I submitted to them, that has who made my dress, where did we get our flowers, what flavor was our cake, all of that information that they were going to use in their blog post about the wedding. So it's out there, whether you have control over it or not. It's out there. Going into the more practical component here of how do you use this wealth of data that's out there in civil litigation. This is, this program is not brought to you by Google, but the reality is that you start with Google. You're welcome. It's very simple. There's a couple of different ways to go about it. You can go ahead and admit that you've Googled yourself. I certainly have in order to prepare for this. But gathering evidence is an art form, and I think that there are a couple of practical tips that I can give you. For instance, if I were preparing a case and I represented a defendant in the case, my first thing that I do as soon as I get the file is I type in the plaintiff's name into Google using quotation marks. I use the full name that I've got for them, but I also throw in as many alternatives as I can come up with. So if my plaintiff is Laura Lee Miller, I'm also looking for Laura Miller, L. Miller in Richmond, Midlothian, if I know that she has a house in Midlothian. Miller, Facebook, Richmond, Virginia. It's helpful to include the specific platform that you're trying to find information on. And when you do this, it's very important to make sure that you actually get the right person out of it. 2 of those images are me, the rest are not. I am on LinkedIn, but 9 of those profiles, only 1 of them's mine. The Laura Lee Miller Twitter has been the bane of my existence for a while now, because I'm not sure if you can read the text up there, it's a bit small again, but the profile says, "I can get a little drunk, I get into all the don'ts, but on my good days I am charming as expletive." That is not my Twitter account. Just throwing that out there. But it's very unfortunate that it comes up on the first page of my search results. The bottom 2, I wish that was me. That's Laura Lee Miller, the president of Vera Wang Licensing, and serves as the key designer of successful Vera Wang women's fragrances, and probably gets to take a lot of very exciting trips. Other stones to turn over. The biggest one is Facebook. That's no news there at all. Most of the population now is on Facebook. It's where people for a long time have been cataloging their day-to-day activities. People register for events on Facebook. They're posting photos. If you have a situation where you have an automobile accident, people will often go on Facebook and tell all of their friends, "I was in a car accident. Wasn't really looking where I was going." That sort of thing. It happens. People do it, and it's astonishing every time. 53% of U.S. residents log onto Facebook several times a day. People spend an average of 35 minutes on Facebook every single day. So you, your client, your opposing counsel, your opposing party, family and friends of your opposing party, your jurors, they are all on Facebook creating a digital trail, I can promise you. Using the search box in Facebook, that's your second step once you get a new case file in. Type in the name and see if you get lucky. You can usually narrow it by the location as well. This is one tip that I think gets a lot of strange looks, but I've had people come back and say that they did it with success. Ask opposing counsel for a description of their client. They will think that it's very strange that you're asking for that information, but at this early stage of litigation, you haven't actually seen the opposing client yet. So you have an opportunity there to say, well, she's a Caucasian, 30-something-year-old woman, she has blonde hair, she's a medium build, whatever information you can get out of them, all they can say is no. But that is a way for you to help narrow down and make sure that you've actually got the right person. One problem that we run into, though, with checking out people on Facebook and all of these various social media platforms, it's Rule 4.2 of the Virginia Code of Ethics, and that states that the lawyer shall not communicate about the subject of representation with a represented party. That means that under the current understanding of Rule 4.2, you could not reach out through Facebook to interact with plaintiff if you know that plaintiff is represented by counsel. But that doesn't stop you from being able to look at what's publicly available. That comes with the caveat, though, that there is gray area in between those two options. I'm sure that there are firms out there that would enable you to get access to, for instance, a Facebook profile that has higher privacy settings than simply posting everything publicly. I'm very confident that those services exist where they would assist you with getting to that less public information. And I don't know the answer to whether or not that would come into conflict with Rule 4.2, but I throw it out there for consideration that it's an ethical problem. Again, you'd be surprised what people post. This is from a case that my firm handled. It's not my case, unfortunately, but this was a photo that was taken a couple of weeks after an automobile accident. That's plaintiff up there having a good time water skiing. Plaintiff claimed leg injuries. Can't make this up. The case, I'm told, resolved favorably. Check the family members of the opposing party. Mom just had her car crashed up. That's one way to get the Suburban that she's wanted for so long. That was another plaintiff. Child did not do her any favors at all, but that was another case that resolved favorably. Lest you think that I'm being biased toward defense attorneys, it does go both ways. You should check your own clients as well. Yes, he liked a page. Yes, I saw the speed limit sign, officer. I just didn't see you. That doesn't look good, and you have that coming up in deposition and they throw it up on the screen when it's videoed. But Facebook is not the only place that we can look now. There are new devices coming out in the market every day that give you access to information that we would have never even dreamt of years ago. Heart rate monitors. Imagine a situation where you have a nursing home client who is alleging that she was not properly monitored because of a heart rate condition, and she has a heart rate monitor. That is critical data for your case. Fitness trackers, they can give you location. They can give you just general information about how much a person is moving. If you have someone who claims that they've been laid up on bed rest, but they have a Fitbit that says that they're taking 20,000 steps a day, that's vital information. Gaming systems, smartwatches, car navigation, doorbells that have video systems, internet-connected devices. I'm going to read you a description of a product that I only found out about this morning. It says, from creating shopping lists to coordinating schedules to playing your favorite songs and movies, the product keeps your life more connected than ever. Any guesses as to what kind of product that is? What was that? Not Alexa, it's a refrigerator. That is the actual product description for the Samsung Family Hub refrigerator. So where we get this information is expanding daily, and it would behoove people to be creative in terms of thinking, what information do I need and where might it be stored? What do you do when you find something out of all of this Googling and you want to be able to show the partners that you haven't just been frittering away on Facebook all day, that you've been trying to do something productive for your client? Print it. I would say print it to PDF so that we're not accused of being stuck in 1995. Maybe we're stuck in like 2010 range, but print it to PDF, date it, authenticate it, send yourself an email, a memo to a file, something along those lines with the date and the website and the time that you found it. Initial it if you want to, place it into a separate folder, segregate it from other files. All of these steps will help you later on when you're trying to get this evidence in front of a judge. It's always helpful to save things as soon as you find them, because you never know when someone might go through and decide to clean up their profile a little bit. If that plaintiff up on the water skis had really thought about it or had heard from their own attorney, hey, have you made any posts to Facebook lately that might not be consistent with what we're claiming? They might have thought, gosh, I should probably take down all of those photos. And so if you have it, then that's great, because one, you have it, and two, you can go make a spoliation argument, and you can get an adverse inference instruction out of that. The next question that comes up in this area is, isn't there some sort of expectation of privacy in this information? And the answer has so far been no. So out of the Pennsylvania Court of Common Pleas, only the uninitiated or foolish could believe that Facebook is an online lockbox of secrets. So courts are generally finding that this information, to the extent that it's public, is discoverable. So private is not the same as not public. Courts have been holding that when you post something to Facebook or other social media sites, even if you have privacy settings that are engaged, it's still not going to protect you in terms of having a reasonable expectation of privacy under, for instance, the Fourth Amendment, because you're still disseminating it to someone. Even if it's a more select population of people, if you have 100 Facebook friends and you share the water ski photo with them, that's no longer public, at least, or it's no longer private. It's more akin to public, at least as far as courts have been deciding things recently. Even private portions of a Facebook page are still subject to discovery requests. I say that there's no real expectation of privacy. The leading case here is Romano v. Steele case. This is out of New York. When plaintiff created her Facebook and MySpace accounts, she consented to the fact that her personal information would be shared with others. That's the prevailing attitude. Probably. There have been some cases that have tried to call this into question in limited circumstances. For instance, out of the Southern District of Indiana, the defendant wanted the entire Facebook profile of the plaintiff. And the court said that discovery of an entire Facebook profile pits two competing ideas of privacy and discovery rights against each other. So there might be limits here, but we're still figuring out what those limits actually look like. The next question for determining whether you can actually use this evidence, if it's not private and they don't have a reasonable expectation of privacy in it, it still needs to be relevant. Those of us who are practicing in civil litigation, we know that relevance is the key standard in discoverability. Courts are generally requiring that a party requesting access to this kind of evidence identify some reason for it. For instance, other than doing your public Google searching, if you were to propound a discovery request to opposing counsel that said, tell me your social media name, tell me all of your social media accounts that you've maintained for the last 3 years, tell me the last year of posts on your Facebook profile, for instance. Those kind of discovery requests are subject to challenge, just like any other discovery request. And the way that parties have been having success in challenging them is by saying that they're exceeding the permissible scope of discovery because they're not seeking relevant evidence. So in the James v. Edwards case, it's a Virginia Circuit Court case, the party wanted all of the plaintiff's networking and social media activity that was not publicly available, and the court said, no, you can't have that unless you give me a factual predicate for every piece that you want. So there are limits here to what you can get, but again, we're still figuring out exactly what those limits are. The next logical question is, if I can't really get it through a discovery request, can I just go right to the source? Can I just subpoena for this information? Can I send a subpoena to Facebook and say, I want the full profile of person, Joe Schmo? The problem is that we run up against a statute that was enacted in 1986. It's the Stored Communications Act. It was intended to protect privacy interests in personal and proprietary information that may be stored on the internet. Very sensible. The problem is that we have run into courts struggling with how to apply this 1986 statute to today's technology and to ever-changing standards of discovery. So the SCA applies to communications stored on the internet by third-party providers. That would include Facebook. That would include your email provider. And courts have generally held that Facebook postings, for instance, are protected by the SCA. That the protection applies to attempts to compel production of those pieces of evidence. And Facebook will generally outright deny subpoena requests. I can tell you that from personal experience. Don't even bother with an out-of-state subpoena. They'll challenge that on those grounds as well. Exceptions, though. There are exceptions that are written into the SCA. Some of those that could come up in a civil case, unfortunately related to child abuse. That can come up in a civil case. Statements that are made to public agents or entities, for instance, if a person were to place a Facebook comment on a government agency's page, making a complaint, and then somehow that's relevant in a civil litigation, you could make a run at trying to get it through the subpoena process. But Facebook's position is and has been that the user, not Facebook, is the party that's obligated to produce the content. So that leaves you with a few questions. How can you get, if you can't subpoena it and you're not really sure that you're even going to find something that's relevant, and you can't really give the court that factual predicate that they're trying to latch onto, how can you get at this? The first thing is that you cannot get it directly. Courts are not at all favoring narrow-tailored discovery requests that are asking for direct access to the account. But in-camera review can be successful. You can tell the court that you are not sure what you might find on the Facebook page, but that you believe that there is discoverable information there and ask for a limited in-camera review. Most judges are going to laugh you out of the courtroom, but people have tried it with success in Virginia circuit courts. Attorney-only review, that's obviously more appealing to the court because the court does not have to sit there scrolling through the Facebook page, but the attorneys can take it on themselves. But I suggest that that requires an enormous amount of civility between counsel. And I think while Richmond, Virginia has a very friendly bar, there are plenty of very good advocates for their clients who would absolutely reject that notion. You could also propose to opposing counsel that if there are some legitimate privacy or security concerns with the information that's on the social media pages, that any issues with respect to that data could be fixed by a protective order. So that's another option that's available. I think that the bottom line is that there's no consensus nationwide, at least, on what information you can pull from social media. There might not even be a consensus within individual courts and states, and I'll give you a couple of examples. California, for instance, home of a lot of these social media companies, says that neither Facebook nor MySpace guarantee complete privacy, no legitimate expectation of privacy. Pennsylvania, on the other hand, says that a plaintiff has to produce the login information and that Pennsylvania would not favor evidentiary privileges. New York says that to permit a party claiming very substantial damages to hide behind privacy controls on a website would be to enable people to share information about how to lead their lives, but deprives the opposing party of access to material that's relevant to a fair trial. So there are a lot of different thoughts on this and about where we draw the lines. Surely the Supreme Court has some thoughts on this, right? Not exactly. Carpenter v. U.S., this was in June of this year. The court held that a warrant is required for police to access cell phone location information directly from a cell phone provider. So there were 4 men that were arrested in connection with a string of armed robberies. One of them confessed and gave the FBI his personal cell phone and then numbers for, I believe it was 15 possible co-conspirators in the armed robberies. The FBI then applied for orders to produce the transactional records that related to cell site information for the target cell phones at call origination points. So that's where your cell phone is using the towers to triangulate its signal. It's also collecting information about where it is physically located. So you could pinpoint this person was at the scene of this robbery, the scene of this robbery, and the scene of this robbery. Let's bring them in for further questions. But Justices Roberts, Ginsburg, Breyer, Sotomayor, and Kagan said that an individual has a legitimate expectation of privacy in the record of their physical movements. This is obviously coming up in the criminal context, but it's not difficult to see how the court could decide to extend some of these protections in the civil context. Kennedy, Alito, and Gorsuch filed separate dissents, which, given that the court's makeup is changing, we could see different decisions coming out down the line. It just remains to be seen. Microsoft versus United States looked like another promising opportunity for the court to take up some of these issues. The question that would have faced the court is whether an email provider served with a warrant is required to provide the federal government with emails when the email data is stored offshore. So I believe that this company was storing email data in Ireland, and this party wanted to get access to the email data. The Supreme Court said, well, there's this new law that's just come out, lucky for us, clarifying Lawful Overseas Use of Data Act, and that requires email providers to disclose the emails. And so we are going to just remand this to the district court to reverse it as moot. As I mentioned earlier, this is an area that is ripe, I think, for the development of spoliation issues. This is something that's going to continue to come up, I believe, just based on the fact that As a user of social media myself, there are times when I look through a profile and I decide, you know, I don't necessarily want to have this photo up anymore, or I don't want to have this post up anymore. And it's not because I'm hiding anything particularly bad I represent to you, but just, you know, changing tastes and different outlook on what you think should be a good representation of you online. That is a problem, though, because if you start deleting things after you have notice of a pending litigation or after you've received a litigation hold letter, then we run into the spoliation issue. So for those of you who are not fully familiar with this doctrine, parties have a duty to preserve any evidence within their possession and control. And for online evidence, that includes anything that the party has the authority or ability to access. So it's a little bit broader reaching than you might otherwise think. Courts have usually put the duty on attorneys once finding that a plaintiff has retained counsel, that counsel has to then inform their client of their obligation to maintain their social media presence and their social media posts. Consequences for spoliation can be very severe. It can result in dismissal. There are also other remedies, for instance, where a court could issue an adverse inference instruction. In practice, how do you work with this? Issue your litigation hold letter as soon as possible, even maybe before you do your first Google search. Issue one not only to opposing parties, but issue one to your own clients. That's a good way to make sure that you're doing what you need to do on your ethics obligations for your client. Not all courts have been as harsh in dealing with spoliation issues, however. I've given you 4 sites here, and I won't read from them. But just for your own information, courts in North Carolina, Kansas, New Jersey have held that this does not necessarily rise to the level of someone going into, you know, we think of the prototypical case of the document warehouse where files used to be stored in file boxes. This does not rise to the level of someone setting fire to the warehouse. This is something that people do as a course of their ordinary activity online during the day, that they go through their social media and they change what content is posted there. So I'm not saying that you're going to get every case dismissed just because a party has deleted a Facebook post. Other courts have held that that is not necessarily required. Once you've got your relevant information and your relevant evidence, you still have to get it in. That requires authentication. And, you know, there's plenty of different ways that people go about this. I would suggest to you that one that I don't see very often that I think is very useful is requests for admission. There was a recent article, I believe it was in the Journal of Civil Litigation, about how parties are not really using requests for admission to their own benefit as much as they could be. And I think this is a great area where you could do that. For instance, rather than having to bring the witness up on the stand and show her printed copies and say, is this your social media profile? Do you recall making this post? Go on and on to lay the foundation for the information that you've collected. You can simply send a request for admission that says, admit that this is your social media profile. Admit that you made this post on such and such date. And that's an easy and effective way to do it. Printouts and screenshots are actually admissible in federal court under the rule about duplicates. That's Federal Rule of Evidence 1003. It's something that you would think it's a simple matter of bringing out printed copies, but it's always good to have that rule in your back pocket if someone were to challenge it. Federal Rule of Evidence 901, all evidence has to be properly authenticated, and it's on the proponent. And that hasn't changed just because it's in the social media context. It's not on the party whose social media you're trying to use to claim that it's theirs and that it's valid and authentic. It's always on the proponent of the evidence. And I think that that's something that's just worth repeating. There are a few different approaches that courts have taken as to whether or not social media evidence has been properly authenticated. 2 different styles have sort of emerged over the past few years. One would be what I'll call the Maryland approach. That's where the trial judge is the ultimate decider of authenticity. So it's basically a model where the judge is a gatekeeper. The burden, as I said, is always on the proponent of the evidence. You can authenticate it by asking the creator if she created the profile. You can have a forensic output of your computer searches in terms of finding the evidence. That's probably the more burdensome way to do it. Or you can get the information, if you can get it, directly from the social media company. So that's one way. There's the Texas approach. Jury decides. Everything's for the jury. That's a much more lenient test. It would rely on the jury to determine what weight to give the evidence, essentially, rather than making it a gatekeeping function at the judge level. We're asking the jury to say, look, do you think that this is really this person's profile? Do you think that they really made this post? What weight would you give it in this case? And I'll close on just a question that I raised a little bit earlier in the talk about ethics. Lawyers can almost certainly, in every state that I have ever looked at, view publicly available information on social media profiles. That is also true with respect to jurors. Attorneys can passively look up jurors. I'm sure that any practicing attorneys who are in the room have had the firm-wide email go out of, here's my juror panel in Henrico. Tell me if you know any of them, and tell me if you've got any thoughts on any of that information. But your knowledge of social media and how it impacts your case is still something that the ABA is considering. The ABA model rules suggest that a lawyer must have knowledge of social media and an understanding of how it impacts their client's case. So the ABA is actually suggesting that you can't ignore this, even if you would like to. A lawyer also, as I said, cannot communicate directly with a party. I think that that's the area where this is going to come up most frequently in terms of ethical concerns. And a lawyer can instruct a client. The next obvious question is, well, if you can't instruct your client to delete pages, can you at least instruct them to make their profiles private? And the answer seems to be yes, at least in terms of what a couple of state bar ethics committees have said so far. For instance, the Philadelphia Bar has said that a lawyer can instruct a client to change privacy settings on social media pages to the highest level of restricted access, as long as it's not in violation of a court order. So this is something that's still developing actively, but like it or not, it's not going to go away anytime soon. This is something that is just part of civil practice today, and I think that those who would prefer not to dig into their clients' social media posts would prefer to trust what their clients are telling them. I would say trust but verify. There's always the possibility that there's something out there that's going to help your case or something that's going to hurt your case, and it's ultimately on us as lawyers to find it. So I'll take questions if there are any, but thank you very much. No one wants to talk about the federal rules of evidence with me?
Hi, thank you. I have a question about going back to Carpenter and cell phones, and if Professor Lane is here, she would, knock me down for forgetting the case from criminal procedure. But in the past, the Supreme Court has said, because cell phones are so integral to the lives, and your statistics, bore that out. Do you foresee courts kind of moving in that direction with other devices, like the refrigerator that you told us about, that is going to control all of our lives in the near future? How do you see the courts kind of, balancing between privacy and access to this information with these new devices that we don't necessarily know how they're going to, how much they're going to permeate our lives?
I think that a lot of it, the day that I read an opinion that discusses whether we have a reasonable expectation of privacy in the contents of our refrigerator is going to be a very, very interesting day for me. But I think that what courts are ultimately going to struggle with is you have, on the one hand, every state has its own rules of evidence and how you can get evidence. Those are not consistent across jurisdictions. You also just have different judges in different jurisdictions who are going to view things in different ways and are going to write opinions that are not going to be consistent, I don't think. So I do think that it's something that courts are going to continue to grapple with, but whether we ever get some kind of unified standard as to what level of device is actually protected, what information specifically on your device is protected, it's going to come up much more in the criminal context simply because there are constitutional rights at play there. In terms of the civil litigation side, I don't know that I would foresee a court saying you can never look at someone's cell phone. I don't think that that's any world that we would be living in realistically. But I think that there are courts now that are starting to recognize that there are still limits that can be put on this, whether they're couching it, for instance, with the federal rule shifting over to the proportionality standard rather than the relevance standard for evidence collection. I think that that's a tool that a court could use in terms of, they're certainly using it in limiting e-discovery, for instance, emails and data that's on laptops. Whether they would use it in terms of limiting what you can get from cell phones, fitness trackers, those sorts of things, I think that remains to be seen.
Thank you once again for coming to speak with us. So I'm thinking about a service with which I have only background familiarity. The Wayback Machine essentially creates mirror images of past activities and past websites. That's why I'm in law school. I can't describe that well. Have you ever heard of anyone using this in a practical setting with regard to litigation, discovery, and are there any ethical implications to using such a service?
I have used it. I will fess up to that, so I hope there are not ethical problems with doing it. As far as my practice would be concerned, I would consider that to be publicly available information because it's still information that I can access on a website without going and getting a warrant or anything along those lines. I don't have to go through an agency or a specific process to do it. So I would consider that to be public information. The way that we end up using it is really in terms of trying to look for any profiles where it's very publicly available, and this is becoming more and more rare as people are becoming wiser to how high their privacy settings should be put. But in terms of looking at a snapshot of a blog, for instance, and finding that they've deleted blog posts, that can sometimes be interesting. That comes up in Tumblr, oddly enough. I've had that come up in a Tumblr case where the person was just, the opposing party was very much in the habit of cataloging their day-to-day life on Tumblr and deleted about a year of Tumblr posts. And so we went onto the Wayback Machine and were able to retrieve not all of them, but a lot of them. And we were able to then propound a discovery request and give us all of your Tumblr posts from such and such year. And it didn't end up reaching the point of a spoliation fight in that case. It resolved before that point. But it is something that I think that the main way that we would want to use it is in terms of finding evidence that's been destroyed. I do think it's possible to do it without crossing ethical lines. But I'm not saying that there could never be an ethical problem with it. I could certainly think of different scenarios where you would be probing too deeply using that kind of a tool.
Thank you. I come from China, and some Chinese scholars suggest that if an internet service provider fails to detect and stop one of its users from harming another, and maybe by assault, that may constitute assault, it should be held liable for that user's tort also. And according to your experience, will that put many difficulty in not only lawyers but also courts in finding the proof that the internet service provider failed to detect what it should have done? And what proof do you think will be enough?
What proof will be enough is sort of the million-dollar question, I think. I'm not sure that I can answer that part of it. But in terms of difficulty of accessing information directly from internet service providers, I think that that's going to be something that for now at least is governed by the Stored Communications Act in the United States. In terms of foreign jurisdictions, I'm simply not familiar enough with what foreign jurisdictions have put in place. I've read a bit about what the EU is doing in this area in particular in terms of trying to expand internet privacy rights, and there are different conflicting views on how effective that is and whether that's really accomplishing the goals that they've set. But, and I'm looking at Rick because he probably knows so much more about this than I do, and I don't want to say anything incorrect here. But I think that it's something that what proof will be enough is ultimately going to come down to the individual court that's making that decision, and it's just something that's going to be very difficult to predict for the at least short term until we start to build some kind of consensus on these issues.
I'm curious about the implication for Facebook groups, because not only do you have the extra consideration of determining whether the privacy of the group outweighs that of the individual whose information is needed, but you also have that third category of group. You have the open group where anybody can see the post and anybody can find the page. You have the closed group or private group where you can find the page and see the page profile, but you can't access the posts. And then you have the secret group, where you can't even search for and find the actual page. So do you argue that the secrecy of this extra private secret group is something that deserves or inspires an extra expectation of privacy beyond the cases you've seen with the individual?
That depends on if it's my client that's in the secret group or if it's the opposing client that's in the secret group. But just from a general perspective, I do think that that's something that courts would take into consideration in terms of, at least for courts that are trying to draw lines between saying you can have access to everything that's publicly available and no, there is some kind of reasonable expectation of privacy. It's certainly simple to think of examples of secret groups that people could be a part of that would be something that would fall under the undue harassment or unduly burdensome objections to discovery. For instance, if someone were in a secret group that dealt with a medical condition that they had that was not an issue in this litigation, I could certainly see a very reasonable objection to information about that secret group. In terms of the open groups, I think that I would say that in any event that that's all still within that publicly available information, and that unless there's some compelling reason as to why a court would limit discovery as to those, that's fair game. But in that gray area where you have a group where you can't see the posts, I think it would depend on whether or not the information is particularly relevant to your case. I mean, you can think of an extreme hyperbole example. You can think of if the person is a member of a group where you can see that the group exists and the group is called Shoplifters Anonymous, and you're dealing with a case where this person has been stealing from your client, the store, and you're trying to recover some of the monetary value that was stolen. I think that's that's something I'm going to try and get at, every single piece of information that I can get at. If it's something where they're in Shoplifters Anonymous, but this is an automobile accident, I might still be interested in that, because it would still maybe be something that gives me a clue as to something I can use to cast doubt on the credibility of the person. But I don't know that a court, if it's applying that factual predicate standard that the one Virginia Circuit Court applied, I'm not sure that a court would agree that that has that same factual predicate.
Again, thank you, as everyone else has said. First a comment and then a question. About 2 years ago, some of the larger internet players like Facebook and Twitter came out with a study about how much money they were spending defending these subpoenas. So they started actually changing their end user licensing agreements to allow them greater latitude to share data without still violating the Stored Communications Act. So it's a shifting landscape. And then we have states in the United States like California who's already passed the new privacy laws, and other states that are following suit that's going to continue to shift the landscape around that. But my question comes in for things like Facebook or other messaging applications. So outside of, not Facebook specifically, but Messenger. So the concept of privilege and privileged communications, where they play in where you can have a one-on-one conversation like an email. Have you seen that come into play?
Absolutely. Yeah, I had a case where we were in a fight about the spousal communication privilege. Communications between spouses are typically, there's some level of privilege that can be applied to them. And we had a case where one of the spouses worked for a defendant corporation. The other spouse did not. And there was a question as to whether or not the spousal communication privilege extended to every Facebook message, and this was their primary mode of communication, whether it extended to every Facebook message that they sent to each other, whether it was only something that could be drawn to the communications that were about or in some way related to the defendant corporate entity, or whether there was some third option that neither of us as counsel were considering in that case. And ultimately what the court decided was that they were going to protect the privilege, and that it was going to be something where they said that every communication between the spouse on a Facebook Messenger style platform, it's the same as sending an email, it's the same as sending a text message, and that's how we're going to treat it. It's a blanket protection. You can't get access to any little bit of it. So that's at least been my personal experience with it. I do think that courts are probably going to be more open to an argument of discovering Facebook messages because of the possibility of adding more people into a messaging group, for instance. But I think it's something where it's going to be very case-by-case basis, and there are going to be arguments on both sides.
I'm sorry if you already covered this, but what do you think about serving subpoenas on Twitter or Facebook, and would you do it?
So I did touch on this a little bit, and the ultimate walk-away conclusion here that I would come to, at least, is that it's certainly possible to serve a subpoena on Facebook and Twitter. In order to make it comply with the Stored Communications Act, it needs to be issued in their home states. They will challenge out-of-state subpoenas, and it needs to relate to one of the exceptions. And I've only had one successful Facebook subpoena, and that was because it was for posts that related to child abuse. And it came up in the context of, it was a very, very messy civil litigation situation where one of the parties was alleging that the defendant's school had contributed to, enabled, or participated in active child abuse. So the fight was about Facebook posts from the parent that dealt with the alleged child abuse. So it was a nasty sort of battle because obviously the parent believed that anything that they posted to their very, very highly private Facebook page was something that was private to their friends and family. And it's very sensitive information. But under the Stored Communications Act, the information that relates to child abuse is something that can be subpoenaed in that way. But in terms of just your average run-of-the-mill automobile accident, something along those lines, it's really something where, based on the decisions that the entities themselves and based on the language of the statute, it's really not worth doing, I don't think, just because they're going to be rejected, they're going to be challenged, and they have a very, maybe they're using the app that was discussed earlier for challenging parking tickets, but they have a very streamlined way of doing it. Serving papers on Facebook. Can you give me an example of what you're...
The DNC subpoenaed WikiLeaks over Twitter.
Okay, that's not something that I'm especially familiar with, I'll confess, but so if I were in active litigation against one of the entities, then the bets go out the window. Then I'm going to try and do whatever I can, but I just haven't been in that particular scenario. All right, thank you very much.
Well, thank you, everybody. Thank you, Nicole, for bringing it all together and bridging the current EIC with the founding EIC. Thank you, Laura, for a really fascinating talk. This is exciting to explore this and get really in-depth on the ethics and implications and what's going on here. And thanks especially to Rick. Always wonderful to hear you talk, and it's great to hear about this. And it's nice how social media came through in all the elements we had. One thing that Rick didn't mention is that he also was on, can I say this? He was on the founding team of Google+, so he's been involved in that. And we know that coming up for Jolt's symposium, we've got social media and the law is the subject matter of it. And they also have, there's a little flyer that you got, there's a student-oriented international writing competition going on right now. Social media is the subject of that. And we heard a lot from Laura Lee Miller about sort of what's going on with social media. But what I'd like to do now is close with two thoughts. One, thank you all. Thanks to Wendy for supporting the law school, providing a great opportunity, and thanks to everybody here for coming, attending, and things like that. And sort of tying through all these here with social media, but what I'd like to do is end with something that's sort of the original form of social media, which is getting together over drinks and food and joining us for a reception afterwards. Let's keep talking here. Our guests are going to be here to entertain questions. We've got members of Jolt here. We've got members of the legal community. Let's talk with each other and celebrate social media in a way that's maybe not discoverable, okay? All right. Thank you very much, everybody.